In his book, The Oath, legal analyst Jeffrey Toobin provides an in-depth analysis of the personalities and ideologies of the 9 U.S. Supreme Court justices. He also comments extensively upon the ideological divisions that are often transparent in particular cases. As Toobin asserts, liberals tend to want flexible rules that allow courts to reach a lot of decisions on the merits, whereas conservatives tend to favor stricter rules which prevent cases from being heard. Of course, there are exceptions to this, but one only need to look at the liberal activism of the Warren Court to see that it was based to a great extent on flexible rules of procedure. Warren and his fellow Supreme Court justices pushed the law into new areas and used this in order to establish new rights. Today, however, Toobin argues that in the vision of Chief Justice John Roberts, Samuel Alito, and Clarence Thomas, among others, the Supreme Court is playing a more narrow role than it had in the past. Of course, this is not to say that all of the conservative justices have the same ideological beliefs. For example, Justice Kennedy tends to view the Supreme Court in the context of an international community of judges. Chief Justice Roberts does not hold this view, nor does Justice Scalia for that matter. Justice Scalia tends to endorse an overarching theory of the Constitution, though the Chief Justice does not. So there are fundamental differences even among the conservative justices as to how they view the law and its relation to society. Needless to say, there is disagreement on the court, and this was famously captured in a quote from Justice Oliver Wendell Holmes, who referred to himself and his fellow justices as 9 scorpions in a bottle. One fairly recent U.S. Supreme Court case that warrants our attention is Ledbetter versus Goodyear Tire and Rubber Company. As Toobin points out in this book, this is an employment discrimination case. In 1979, Lily Ledbetter, the plaintiff, began work at the Goodyear Tire and Rubber Company. She started with the same pay as male employees, but by retirement she was earning substantially less pay than similarly situated male employees. Ledbetter decided to sue, and when this case eventually made its way to the U.S. Supreme Court, the court rejected Ledbetter's claim in a 5-4 decision. What's noteworthy is that the court rejected the claim on statute of limitations grounds. Justice Samuel Alito, who wrote the majority opinion, argued that the plaintiff should have filed an EEOC charge within 180 days after the allegedly discriminatory action had taken place. However, because she did not, there was no liability. Of course, this decision does not take into account that a plaintiff may understandably face enormous obstacles in doing this. Toobin uses the Ledbetter case as an example to illustrate the tendency among conservative justices to avoid deciding a case on its merits and to instead follow strict procedural rules. It is noteworthy that the Ledbetter case was a 5-4 decision, and the senior justice on the dissenting side, who was Justice John Paul Stevens, assigned the dissenting opinion to Justice Ruth Bader Ginsburg, who had very strong feelings about this issue. Not only did Justice Ginsburg write a scathing 6,200-word dissent, she passionately read excerpts from her dissent from the Supreme Court bench. And Ginsburg even called upon Congress, another branch of the U.S. government, to take action and essentially nullify the decision of her conservative colleagues. Very rarely in the history of the court has a Supreme Court justice taken action such as this, and her plea did not go unnoticed. As Toobin contends, this immediately drew the attention of Democratic legislators who had just won control of both houses of Congress. Justice Ginsburg's plea for Congress to act would culminate in the Lilly Ledbetter Pay Act of 2009, which is a federal statute that was the first bill signed into law by President Barack Obama on January of 2009. The new act states that the 180-day statute of limitations for filing an equal pay lawsuit regarding pay discrimination resets with each and every new paycheck affected by that discriminatory decision. While many scholars agree that Justice Ginsburg's actions most likely help to result in higher compensation for women in the workplace, there are broader questions which may be worth asking. For example, is it appropriate for a Supreme Court justice in his or her official capacity to directly appeal to Congress from the bench? Should a Supreme Court justice be permitted to call on another branch of government to nullify a decision made by the majority of his or her colleagues? Does this violate the principle of separation of powers, or can this type of action be justified depending upon the circumstance or case? These are important questions that are worth asking and certainly worth a considerable amount of discussion and reflection. Another fairly recent U.S. Supreme Court case that warrants our attention is the 2008 case now known as District of Columbia v. Heller. District of Columbia v. Heller is a landmark case in which the Supreme Court of the United States held in a 5-4 decision that the Second Amendment to the United States Constitution protects an individual's right to possess a firearm for traditionally lawful purposes, such as self-defense within the home and within federal enclaves. This is the first Supreme Court case in United States history to decide whether the Second Amendment protects an individual right to keep and bear arms for self-defense. As Toobin points out in his book, the split among the justices in the Heller case was a familiar one. Stevens, Souter, Ginsburg, and Breyer dissented in this case. Justice Souter, incidentally, is no longer on the court and was succeeded by Justice Sonia Sotomayor about a year after this decision. Had Sotomayor been voting, however, it is likely that she would have voted the same way as Souter had. There was and continues to be an ideological division between conservatives and liberals on the U.S. Supreme Court, and this division may be even more pronounced today than it was in 2008. One of the things that Toobin finds to be a bit disconcerting about the Heller case is the legal reasoning that Justice Scalia used to justify the decision reached by the majority of the justices. As Toobin argues in his book, Scalia's decision had little to do with the original meaning of the Second Amendment. Rather, Toobin asserts that Scalia's majority opinion was an improvisation designed to reach a policy goal which was one of the top priorities of the modern-day Republican Party. These are very strong words, especially in light of the fact that Scalia presents himself and purports to be an originalist who interprets the Constitution according to the intent of the Founding Fathers. Toobin, however, argues that Scalia did not do this in the Heller case. He contends that if Scalia were truly an originalist, he would have argued that the Constitution protected an individual's right to possess military weapons. But Scalia did not do this. Rather, he limited his ruling for the court in Heller to handguns. Toobin points out that this demonstrates an inconsistency in Scalia's logic and that he is merely using his position as a justice to achieve political goals for the Republican Party. This is a scathing indictment, I think, on Justice Scalia and is definitely worth further consideration. I think it is also important to point out that the Heller decision did not address the question of whether the Second Amendment extends beyond federal enclaves to the states. This would be addressed a year later in McDonald v. Chicago, a 2010 landmark decision of the Supreme Court of the United States that determined whether or not the Second Amendment applies to the individual states. In this case, the court held that the right of an individual to keep and bear arms protected by the Second Amendment is incorporated by the Due Process Clause of the 14th Amendment and applies to the states. The decision cleared up any uncertainty left in the wake of District of Columbia v. Heller as to the scope of gun rights in regard to the states. And as in the Heller case, this was also decided on a narrow 5-4 margin, with all of the usual suspects voting in the predicted direction. Justice Alito, who would write the majority opinion, was joined once again by his conservative colleagues, Chief Justice Roberts, as well as Justices Kennedy, Scalia, and Thomas. Justice John Paul Stevens, who was the senior justice on the dissenting side of the case, assigned himself the dissenting opinion and was joined by his liberal colleagues, Justices Breyer, Ginsburg, and Sotomayor. I cannot emphasize enough the importance of both the Heller and McDonald cases. Both are particularly relevant and will have a profound impact on criminal justice policy in the years to come. The court handed down decisions which are supported by gun rights advocates, including the National Rifle Association, and it is unlikely that Congress will attempt to pass any meaningful legislation that will invalidate either of these rulings as it did in the Ledbetter case. The reason for this is because it's not politically popular for either Democrats or Republicans to lobby behind laws which restrict gun ownership. In fact, when President Obama was a junior senator in Illinois, he was asked point blank about gun ownership, and he essentially dodged the question. Even in spite of the alarming amount of mass casualty shootings that have occurred within the past few years, we are unlikely to see serious attempts by Congress to restrict guns. For the time being, the court has had the last word on this. Nevertheless, I think it's worth noting that both the Heller and McDonald cases were decided on very narrow margins. They were both 5-4 decisions. Therefore, if one of the next U.S. Supreme Court justices who is a conservative retires and then is replaced by a liberal Supreme Court justice, this could change. But keep in mind that the conservative justices do have time on their side. They are all fairly young. More than likely, the next justice to retire will be Ruth Bader Ginsburg. She is one of the most, if not the most, liberal justice on the U.S. Supreme Court. So if Bader steps down and then is succeeded by another liberal justice, nothing is likely to change in regard to this issue. The U.S. Supreme Court is indeed, I think, a fascinating institution, and while the Founding Fathers did everything they could and went out of their way to insulate it from politics, it's still, like any other institution of government, tends to be highly immersed in the world of partisan politics, according to Jeffrey Toobin.